It's a very painful situation to find yourself in where you've married somebody from abroad, spent a lot of money, they've come here and the relationship has broken down. Alternatively, it's a very painful situation once again if you are abroad and you've come here to the UK after having married somebody and the relationship is not working out because of domestic abuse. In these circumstances, a lot needs to be considered. We're going to consider domestic abuse within 5 questions. The first is, what is domestic abuse? The second is, who can claim domestic abuse and what forms do you need? Third is, what are the requirements of domestic abuse? The fourth is, what if somebody is lying on their domestic abuse application? What if they are in fact the abuser? And the fifth is, how can we as lawyers help you in your domestic abuse application? Domestic abuse legislation doesn't apply to every foreign national. You have to be part of a particular category. The categories are as follows. Someone who is a partner under Appendix FM, somebody who is a partner under Appendix EU, somebody who is a partner under Appendix Family Reunion, somebody who is a partner under the work routes or the study routes, and somebody who has been abandoned back in their home country because they were a partner of one of these routes and their partner abandoned them so they couldn't avail the protection of domestic abuse legislation here in the UK. These are the people to whom this particular application with the Home Office in regards to domestic abuse applies. In terms of the forms that you need to complete for people who have been abandoned out of the country, they are going to complete the form called Return to the UK. For people who are in the UK and are applying with their children, they and their children are going to be completing Set DV. For those who have already applied and now their children are going to be applying from within the UK independently of them, the children are going to be completing Set F. In terms of the requirements, the first is suitability. You need to be able to satisfy to the Home Office that it is suitable for you to make this application and for them to accept it. Within suitability, we have the grounds of refusal. The grounds of refusal have 2 parts to them. The first is applications that must be refused, and the second is applications that may be refused. Because of the nature of this type of application, anything that is discretionary, the Home Office have power to look at it and exercise that discretion if necessary. I'll give you an example. Let's say, for instance, somebody has breached immigration rules previously in the UK, but their passport and everything to do with their immigration status was controlled by their partner, who happens to be the abusive party in this situation. In those circumstances, it would be just and proportionate for them to disregard the fact that the person has previously breached immigration rules. So in this sense, anything that is discretionary, where you do not meet suitability and it leads back to the abuser itself, we can certainly argue that you should not be prejudiced. In relation to other requirements associated with eligibility, you've got the requirement that you must have been granted leave last as one of the appendixes that I mentioned earlier, that the relationship broke down as a direct consequence of domestic abuse, and that's talking about the relationship between you and your partner broke down as a direct consequence of the domestic abuse between you and your partner or other family members. And finally, we've got the Life in the UK test, which you do not need to sit. But what if somebody's lying about having suffered domestic abuse and is simply making this application as an application of convenience, and in fact they are the abuser? Well, the Home Office have said in their guidance that their route is not intended to benefit people like this, and rightly so. This is a very important point when it comes to counter allegations. Now, we can help you in 2 ways. We can help somebody who is legitimately claiming domestic abuse, and we can also help somebody who is a victim of somebody falsely claiming domestic abuse. In terms of the first aspect, if you're legitimately claiming domestic abuse, we can help you by telling you what type of evidence you need. We're going to do a separate video on evidence, so follow for that. We can help you by completing the application form by drafting a cover letter which has the legal and factual arguments that are necessary in order to represent your case. You can do it quickly and confidentially, and we can tell you where to source certain types of evidence that are difficult to get hold of. Conversely, if you are someone who is a victim of somebody falsely claiming domestic abuse, the Home Office have a duty to look at all the circumstances together, which includes your side of the argument. Now, they're not just going to give weight to your side of the argument without it having evidence and without it being persuasive. So it has to be persuasive, it has to be articulated properly, and it has to be backed up by evidence. We can certainly help with suggesting the kind of evidence, we can certainly help with witness statements, and we can also help with articulating it to the Home Office in a cover letter with Once again, legal and factual arguments relating back to the domestic abuse legislation and showing the Home Office how this person is actually making an application of convenience if that is the case. I'll do another video explaining this in detail at some point, so follow for that. But for now, feel free to get in contact with me. Just bear in mind that I do not do legal aid work. All my work is privately paid, and I'll be happy to take a look at your case.